Hello again, class. I inadvertently stopped short on the first part of chapter 36, the video I made for the first part of chapter 36. And so I'm going to start the second part with the problem that I intended to include in the first part of chapter 36. All right, so we talked about sole proprietorships in that first half of chapter 36. And so just to have an illustration, I have chosen issue spotter number 1 from your text. It'll be a pretty straightforward problem, but just so you have something to connect with what we talked about. So let me read through it first here. It says, Frank plans to open a sporting goods store and to hire Goji and Hap. Frank will invest only his own funds. He expects that he will not make a profit for at least 18 months and will make only a small profit in the 3 years after that. He hopes to expand eventually. Now, would a sole proprietorship be an appropriate form for Frank's business, and why or why not? All right, so you probably can take this in and already spot some of the issues that Frank is grappling with. So here, he doesn't expect to make a profit. That's what we're told. And so since he's going to run the business on his own and have full control of it, it probably would be a very appropriate business form for Frank to use a sole proprietorship. And as he grows, he might consider changing that business form. Maybe in 18 months he takes on a partner and they may discuss and negotiate a partnership. Or maybe, some opportunities come Frank's way in the future and he needs to be in more places, expand his business to cover more territory. And in that case, a corporation might serve his needs better at that time. All right, but for the moment, when he's starting out, he can certainly start out this way with a sole proprietorship. All right, so I hope that gives you some illustration to go along with the sole proprietorship, and we're going to move right now into franchises. Oops, let me see if I can get down there. All right, so here I put a definition of a franchise up for you. All right, franchises are not only operated by sole proprietorships. They can be operated by partnerships, any other type of business entity. I believe the reason the authors of the textbook put it here with sole proprietorships is, well, it's a short topic to cover. Sole proprietorships is another short topic to cover, so it makes some sense in a textbook to put the textbook together this way. But keep in mind that franchises can be owned by any type of business entity. All right, so you probably have some experience with a franchise. You probably have an idea of what it is, but here's a legal definition for you. It's a relationship where the owner of a trademark, a trade name, is a way of doing business. This person is called a franchisor. Okay, they own this special name or brand or way of doing business. They allow another person or entity, a franchisee, all right, to use that trademark or trade name, that way of doing business under specified conditions. All right, they have a contract with each other for the use of whatever the franchise owner has, the trademark, the trade name, the way of doing business. And so, we can just look at Colorado Boulevard and you can see a number of franchises, right? You see the McDonald's, you see the Jack in the Box. Those are well-known franchises, right? Now, franchises, sorry, I have to bend over and advance the slides, can be operated in 3 kind of basic ways, all right? So we have a distributorship franchise where the manufacturer licenses a dealer, all right? So the franchisor manufacturer licenses a dealer, franchisee, to sell a product. Sometimes they give them an exclusive territory. That would be an auto dealership, all right? Now, second, you have a chain store model of franchise. The franchisee engages in the franchisor's business and operates under the franchisor's trade name. And so we just talked about McDonald's and other fast food restaurants. Those are good examples of the chain store style of franchise. The third way you might see a franchise would be what we call a manufacturing or processing plant. type of franchise. Here, the franchisor permits the franchisee to use a special recipe or some ingredients to make a product. Think of something like Coca-Cola or some other kind of brand that has a special ingredient. All right, so they license the franchisee to manufacture or process that good. All right, now, there are franchise laws on the books, there are regulations. For the most part, franchise relationships are governed by state law, but there is some federal law that does provide us some guidance in this area. That federal law, you'd find it that it's been promulgated by the Federal Trade Commission, and a lot of the law has to do with disclosures, right? Well, that's one of the key aspects to learn about when you look at franchise law. What are the disclosure requirements, right? So to protect an investor, this is what Congress has enacted, or the regulatory agencies have enacted, all right? The requirement that a franchisor make written disclosure of specific information. All right. In addition, other topics covered by franchise agreements negotiated in anticipation of a franchise agreement would be, for instance, the payment. How will payments be made? When will payments be made? What will the payments be regarding? And so I have a short list here, right? Payment that the franchisee might have to make would include perhaps the initial fee for the franchise license, perhaps the cost of equipment or products needed in the outlet, right? What percentage of annual sales will have to be given to the franchisor, and what contribution for advertising or administrative costs for the national franchise will an individual franchisee have to make. All right. Additionally, franchisors may specify certain aspects of the franchisee's business. For instance, number one here, whether the franchisee is able to lease or do they have to purchase the business premises. What location can the franchisee consider? And what business structure can the franchisee use? All right. Additionally, we're talking about quality standards and even suggested prices that the franchisee might have to charge. Right. And then lastly, we can take a look at an area where there are quite a few arguments between franchisor and franchisee, and this would be around the area of termination. And I'm sorry, I think my little screen has blocked part of this slide. Let me see if I can remove it for now and then just have the slide. Oops, sorry, I went the wrong way. There we go. Oh, that's not what I wanted. Oh well, I have to leave it for now. I'll work on that in the future class. All right, so third topic regarding issues that might be negotiated between franchisor and franchisee would be termination. All right, and usually the issue, what we're concerned with here is that if you're the franchisee, you want to be concerned with if it's possible for the franchisor to basically cut you off. All right, and under what context would they be allowed to do that, to stop doing business with you? So you would want to see in the contract that termination of a franchise be for a cause, all right? Some breach of the franchise agreement, something perhaps related to bankruptcy, insolvency, or death of the franchisee, right? If it is for cause, if you're the franchisee, you want to have a chance to cure that. You want to have a chance to cure the default, all right? So the case law that you'll run across, you'll see arguments over wrongful termination, and the franchisee will argue that they did not have opportunity to cure the breach that they're accused of. But case law shows us that in many cases, the franchisor's right to terminate is enforced. All right. Again, it's factually based. It depends on what type of circumstances the franchisee finds him or herself in. All right. When it comes to terminating the franchise, notice is very important. Notice is required prior to termination. The notice period is set by the franchise agreement, and if there's none set, it will be a reasonable notice period. All right. And now let's talk about good faith. There is a duty for the franchisor to act in good faith. And so this issue comes up occasionally. We have a case in your book. It's called Schick-Miller Chevrolet. And in this case, the court found that the franchisor had acted in good faith, that there was cause to terminate. And in the Holiday Inn case, what happened there is the franchisor terminated the franchisee after giving promise of renewal. So this gave us the opposite result. The franchisor had acted somewhat fraudulently, right? Had committed fraud by promising one thing and not following through with it. And so the court found that, yeah, there was lack of good faith there, and so ordered the franchise to pay compensation and in addition added punitive damages. All right, now I'd like to take a look at the reviewing problem. The reviewing problem comes at the end of the chapter. All right, it's a good way to kind of get a good overview of the topic we've been covering. This particular reviewing problem, though, only deals, it deals mostly with the ideas of franchise, the concept of franchise. All right, so here's what happened in the reviewing problem, and I've just copied it straight from your text just to make it easy and put it into a slide here, but you can find it at the end of the chapter. All right, what happens? Carlos Del Rey, he decided to open a Mexican fast food restaurant. He signed a franchise agreement with a national chain called La Grande Enchilada. The contract required the franchisee to strictly follow the franchisor's operating manual and stated that failure to do so would be grounds for terminating the franchise contract. The manual set forth detailed operating procedures and safety standards and provided that a La Grande Enchilada representative would inspect the restaurant monthly to ensure compliance. All right. Now, 9 months after Del Rey began operating his restaurant, a spark from the grill ignited an oily towel in the kitchen. No one was injured, but by the time the firefighters arrived and were able to put out the fire, the kitchen had sustained extensive damage. The cook told the fire department that the towel was about 2 feet from the grill when it caught fire. This was in compliance with the franchisor's manual that required towels be placed at least 1 foot from the grills. Nevertheless, the next day, La Grande Enchilada notified Del Rey that his franchise would terminate in 30 days for a failure to follow the prescribed safety precautions or procedures. Using the information presented in the chapter, we're going to answer these questions. All right, so number 1, what type of franchise was Del Rey's La Grande Enchilada restaurant? All right, well, it is apparent that it is a chain-style franchise. All right, there's the license for use of the name of the business, the franchisor's business, and basically the way it operates. Okay, the restaurant. All right, number 2. If Del Rey operates the restaurant as a sole proprietorship, who bears the loss for the damaged kitchen? And explain. All right, sole proprietorship, single owner, Carlos Del Rey. He has personal liability. He's going to bear the loss for the damaged kitchen. Now, to offset that loss, he should have insurance, business insurance, to cover the loss there. All right. Number 3. Assume that Del Rey files a lawsuit against La Grande Enchilada claiming that his franchise was wrongfully terminated. What's the main factor that a court would consider in determining whether the franchise was wrongfully terminated? All right. What did we just learn? Main factor that a court considers is whether the franchisor has acted in good faith and fair dealing. So they would examine the context for Carlos's termination, termination from the franchise agreement. What are the factors that came into play here? I know they didn't give us a lot of explanation in the problem, and so that will lead us now to question 4. Would a court be likely to rule that La Grande Enchilada had good cause to terminate Del Rey's franchise in this situation, and why or why not? All right. It didn't seem like there's much. It'd be very thin, the facts used here to terminate Carlos Del Rey's franchise, based on the only testimony available from the cook, right? It seems like the franchise was in compliance, right? The towel was appropriately placed. It was not too close to the flame, all right? And so it does not seem like La Grande Enchilada has enough of a reason or good cause, all right, to terminate the franchise, all right? So that brings us now to the end of the chapter. It was a pretty short chapter, and I hope that the concepts were not terribly difficult in chapter 36. I have already placed up online for you the vocabulary for this chapter. These terms come off the vocabulary list for the most part. Occasionally I do add a term or two, depending on the chapter and the content. And so you can find that all listed in the modules, the vocabulary list for this particular chapter. Now I might just say, if you haven't noticed, that most of these terms then, if they're in the textbook already on the vocabulary list, they're hyperlinked to the glossary, and so you have access that way, as well as the flashcards in MindTap that you can use to help you learn the terms. All right, so please take note of those and use them if they are helpful to you. All right, I'm going to close out right now, and I'll be seeing you in our next video, chapter 37.